Mr. Speaker, and I'm very pleased to rise in the House today to address C7 and speak to our proposed changes to Canada's medical assistance in dying legislation.
The proposed measures are, as you know, in response to the Truchon decision by the Quebec Superior Court, which held that it was unconstitutional to deny access to medical assistance in dying to people who meet all the other eligibility criteria but who were not near the end of their lives.
To this ruling, the Government of Canada has had the opportunity to consider some additional measures for where there is strong support. That is why we are proposing changes that will help clarify and add precision to Canada's medical assistance in dying legislation. Over the past few months, I've had the honour of listening to many Canadians, and it was important for me as Minister of Health to hear firsthand what they had to say. My colleagues and I hosted a series of roundtables and heard from more than 125 experts, academics, ethicists, doctors, nurse practitioners, members of the disability community, Indigenous groups, and key stakeholders. I also engaged my provincial and territorial colleagues, and my officials worked closely with their counterparts across the country. In January, I was in Calgary, and I spoke to Cynthia Clark, who saw her husband through the process of medically assisted death last summer. Her perspectives, as well as those of so many others with first-hand experience, were invaluable. I also listened to practitioners who have been providing medical assistance in death in a very thoughtful, compassionate way over the last 4 years, and they had a lot to say about what was working well, but also what was not working well. We heard many personal stories, like Cynthia's, that helped shape the changes that we are proposing today. In addition, the feedback received from our online consultation was astounding. In 2 weeks, we had more than 300,000 responses. Est-il clair?
And it is clear that a number of changes could be made to improve access, respect choices, and protect vulnerable people. I believe that with this bill, we have struck a balanced approach that better reflects the best interests of all Canadians.
Mr. Speaker, protecting the safety of vulnerable people while respecting the autonomy of Canadians remains our central objective. And that is why the bill proposes a two-track approach to safeguards, based on whether or not a person's death is reasonably foreseeable. Reasonable foreseeability of natural death would no longer be a requirement for determining whether a person can access medical assistance in dying. It would, however, be used to guide practitioners in determining which safeguards to apply. And this is consistent with what we heard at the roundtable meetings. Providers involved in assessing the eligibility of applicants for a medically assisted death told us they have a good understanding of the concept and are comfortable applying it. Under the amended law, they would use reasonable foreseeability of natural death to determine not eligibility, but rather which safeguards would apply. For those whose death is reasonably foreseeable, we would ease some of the pre-existing safeguards. Under the current system, there is a requirement for a 10-day reflection period. We are proposing to eliminate this reflection period. For those who are at the end of their life, the decision to request medical assistance in dying is well considered, and this additional period only serves to prolong suffering unnecessarily. The current system also requires that 2 independent witnesses confirm that the person who has signed a request for medical assistance in dying is who they claim to be, and that no fraud has occurred, such as someone forging a signature. During our consultations, we heard that this requirement was a significant barrier for many people at the end of their life. We propose requiring only 1 witness and allowing this witness to be a paid personal or healthcare provider. These individuals naturally would be excluded from acting as a witness if they are a beneficiary of the person's will or if they would receive a financial or material benefit from the person's death. Anyone involved in assessing or providing medical assistance in dying would continue to be ineligible to serve as a witness. And for those whose death is not reasonably foreseeable, we would create a new, more robust set of safeguards. We think it is important, even while improving access, to ensure that people who are suffering but who are not dying are given full and careful consideration as they assess whether or not to pursue an assisted death. Strengthened safeguards would also serve to protect vulnerable individuals. For example, the bill proposes a minimum period of 90 days for assessing a MAiD request in the case of a non-imminent death. This period would allow for exploration, discussion, and consideration of options to alleviate suffering by the person seeking medical assistance in dying, and with the practitioner. The bill would also require that the person requesting MAiD be provided with information on available counseling, mental health supports, disability supports, and palliative care as part of the informed consent process. We know that the majority of practitioners are already ensuring that their patients are aware of all of the supports and options that are available to them. This provision underscores the importance of the doctor-patient relationship. It allows for a practitioner and a patient to decide whether medical assistance in dying is the right step and provides sufficient time for the patients to discuss and consider other treatment options, crucial for patients who are weighing this kind of decision. This, Mr. Speaker, supports fully informed decision-making and individual autonomy. Mr. Speaker, under the current legislation, those who become incapacitated lose their eligibility for medical assistance in dying because a person must give their consent immediately before the procedure. This means that some individuals deemed eligible for medical assistance in dying have chosen to end their lives earlier than they wanted out of fear of losing the opportunity to receive the service. That is why we're proposing to include a waiver of final consent for persons whose death is reasonably foreseeable and who have been assessed and approved to receive medical assistance in dying. Individuals at the end of their life who risk losing their decision-making capacity before their chosen date would have an avenue to receive MAiD without worrying that loss of their decision-making capacity before their chosen date would disqualify them. Support for this amendment is strong amongst stakeholders, Canadians, and health practitioners. Canada has had 4 years to reflect on the current MAiD legislation passed in June 2016, and there are many complex issues that require further study. In December of 2016, the Government of Canada asked the Council of Canadian Academies to conduct independent review on 3 specific types of requests for medical assistance in dying that are currently outside of the scope of the law. Requests by mature minors, advance requests, and requests where a mental disorder is the sole underlying medical condition. The Council of Canadian Academies convened a multidisciplinary panel of 43 experts to review an extensive body of evidence, including Canadian and international academic and policy research.
We tabled those reports in Parliament in December of 2018. They provide a comprehensive and well-thought-out review of these very difficult topics. Mr. Speaker, I would encourage all members to read those reports as we pursue our discussions on the proposed changes to the Act and the parliamentary review, which will be launched later this year.
There is agreement amongst experts that allowing advance requests for people with illness, such as Alzheimer's disease, well before they would otherwise be deemed eligible is very complex and will require careful consideration and consultation before it could be included in legislation. During the roundtables, I heard directly from healthcare providers who expressed discomfort because they have seen patients who, as their condition progresses, might not have the same desire for medical assistance in dying as when they were first diagnosed. The Council of Canadian Academies expert panel report on advance requests came to the same conclusion. At the same time, we know that many Canadians have expressed an interest in advance requests so that they could have the comfort of knowing that they could avoid extreme suffering at some future date. For all these reasons, we believe this issue is deserving of deeper examination through the parliamentary review. That will be our opportunity to tackle questions that are profound and difficult to answer, even for practitioners who have been providing this service over the past 4 years. Mr. Speaker, the proposed changes to the medical assistance in dying legislation would exclude persons if mental illness is their sole underlying medical condition.
That does not mean that people with mental illness would not be eligible. It means that mental illness cannot be their sole underlying medical condition. This is another complex area that warrants further discussion.
Federal legislation came into force in 2016. Health Canada has released 4 federal interim reports that provide more information on how the legislation is being implemented across the country. In November 2018, we implemented regulations that resulted in the creation of a permanent monitoring regime which sets out obligations for reporting on medical assistance in dying cases by doctors, nurse practitioners, and pharmacists. The first monitoring report under these regulations is expected to be released in spring of 2020. Since MAiD legislation was enacted in 2016, more than 13,000 Canadians have chosen this option of a medically assisted death. This is not unexpected. We have seen a gradual increase in the numbers over the last 3 years. The number of medical assistance deaths in Canada, slightly under 2% of all deaths, is in line with international regimes. Increasing use of MAiD is largely because of enhanced awareness of it as a legal option and greater acceptance by Canadians. The federal government recognizes that public reporting is critical to ensuring transparency and public trust in the legislation. And that is why we're also proposing changes to expand data collection to help provide a more complete picture of medical assistance in dying in Canada. Under the current legislation, only practitioners who receive a written request for MAiD and pharmacists who dispense a MAiD substance are required to provide information. But it has become clear that capturing information based solely on written requests for MAiD received by physicians and nurse practitioners has resulted in an incomplete picture on who's requesting MAiD across the country and why. The amended legislation would authorize new regulations to be developed in partnership with provinces and territories to allow for the collection of data on all assessments for MAiD. And this would include those undertaken by other health professionals in the care team. It also clearly aligns with the original intent of the legislation to collect information on all requests and cases of MAiD in Canada. Mr. Speaker, I think we can agree that Canadians with life-limiting illnesses deserve the best quality of life possible as they approach the end of their lives. Palliative and end-of-life care provides patients with relief from pain and distress associated with the challenges of living with a life-threatening illness. Supporting home care and palliative care is a key priority in our ongoing efforts to improve our healthcare system. Through Budget 2017, we made historic new investments in healthcare to improve access to mental health and addiction services, as well as home and community care, which included palliative care. And to further support access to palliative care across the country, the government worked closely with provinces and territories and stakeholders to develop the framework on palliative care in Canada, which we tabled in Parliament in 2018. And we have released an action plan to support each of the priority areas identified in the framework. Mr. Speaker, I want to assure you that the proposed bill responds to concerns identified by practitioners and experts through the roundtable discussions.
I will continue to work in close cooperation with provinces and territories, as well as with key partners, to support the implementation of the amendments proposed to this legislation if they are adopted by Parliament.
Working with provinces and territories, health system partners and regulatory bodies to support best practices and information sharing on clinical guidance and other aspects of implementation, which includes training and retrospective reviews. I have a great deal of respect for the practitioners who've been providing this service over the last 4 years with immense diligence and a huge amount of compassion. Their experiences have helped us craft legislation that much better meets the needs of Canadians. This law is constructed in a way that supports autonomy, but with flexibility that allows for a practitioner and a patient to work more closely together. Medical assistance in dying is a complex and deeply personal issue. In tabling these changes, our government has considered carefully the need for personal autonomy and the protection of vulnerable peoples. There is strong public support for change, and Mr. Speaker, I believe that we have found an approach that reflects the best interest of all Canadians. I urge all members of this House to support the proposed changes. Thank you.
Questions and comments. Question commentaire. The honourable member for Cloverdale, Langley City.
Canadians who are deciding whether they wish to receive medical assistance in dying are often experiencing prolonged suffering. The problem is their prolonged suffering is due to lack of palliative care. We were promised $3 billion to go to palliative care. Our dear member, Mark Warawa, spent 9 days in hospital before he even saw a palliative care doctor. I'm wondering how in God's green earth we think that this is the better way by loosening these guidelines to ensure the best quality of life for Canadians.
Minister of Health.
Well, thank you, Mr. Speaker. And as the member opposite knows, we've made historic investments through provinces and territories to improve a range of healthcare services, including palliative care. As I mentioned in my speech, it's been an honor to be part of a government that understands that having a strong framework, actions that we can agree to take together to improve palliative care at the end of life is clearly very important to all of us, as especially we have an aging population that will require more and more of those services. But it is also equally important to recognize that Canadians have very loudly said, and courts have agreed, that they deserve to have autonomy at the end of their lives, and that includes choice to use medical assistance in dying. Thank you.
Questions and comments. The Honourable Member for Montcalm. Thank you, Mr. Speaker. One comment first. With respect to palliative care, it's really important, but I would remind people that the Conservatives were the first ones to approve health transfers, and if there had been enough transfers at 25 cents to the dollar, there would have been enough palliative care. So with respect to the Baudouin ruling and the condition of the state of health of Mr. Truchon, well, these people were entirely excluded from having a choice. When we talk about free choice, you have to have options. How come the minister, if she says that there are practitioners who are able to see that there are people who have Alzheimer's who are in first favor of MAiD, and then they're able to see that they may have changed their minds. If they're able to see that they changed their minds, how come they're not eligible like Ms. Truchon or Gladu would have been? The Honourable Minister of Health. I'd like to thank my colleague for his question.
I agree with him that it takes a long time to recover from a decade of a lack of investment in healthcare across this country under the former Conservative government. So we are doing our best, Mr. Speaker, to make up for lost time. I will say that in the case of conditions such as Alzheimer's, where people anticipate how they might feel if they have a condition, it is much harder to do those assessments. We heard this actually from practitioners who work very closely with patients in all kinds of different situations, and who said that when a person anticipates how they might feel when they are suffering from a particular condition, it can often be dramatically wrong. When a person actually arrives there, they do not have the same kinds of feelings that they might think they have when they, for example, have a traumatic injury. And so for this case, Mr. Speaker, we believe that advance requests require further study so that we understand the implications from a patient perspective and a practitioner perspective.
Questions and comments? The Honourable Member for Timmins, James Bay.
Speaker, I'd like to thank the Honourable Minister for her work on the corona virus crisis. She's been very clear on a number of issues. I am concerned when I hear this debate, though, because our Parliament voted when I was working on the palliative care motion, and we had everyone support the issue of palliative care. And I met with groups across this country about end of life. And what we heard again and again and again about dignity in dying and the rights of people was that they needed those rights to access palliative care. That was what we heard in every group that I ever met with. And yet the only movement that we've seen from the government, it was mandated by the Supreme Court. I understand that. I understand we had to put this legislation in place. But I'm concerned that the Parliament of Canada voted on a national palliative care strategy to work with the provinces and the territories to put in place the opportunities so that people could truly die with dignity with their families in a much more healing and holistic manner. And yet we've seen a lot of talk about that, but only as an addendum to this conversation about assisted dying, but we've seen no resources or commitment on palliative care.
Minister of Health.
Well, thank you, Mr. Speaker, and I will remind the member that through Budget 2017, in fact, Canada made historic new investments in healthcare, which included $11 billion over 10 years to improve access to mental health and addiction services, as well as home and community care, including palliative care. And in August of 2019, Health Canada released an action plan that defines federal activities and the next steps linked to the framework on palliative care in Canada. There are a number of actions that we need to take collaboratively with provinces and territories. We'll continue to work with everybody, including the provinces and territories, to ensure that we can improve the quality and availability of palliative care for all Canadians. Thank you.
Questions and comments. Kese Kamanta, the honourable member for Dufferin-Caledon.
Thank the Minister for her speech. She mentioned that there are safeguards in place for people that suffer from only mental health issues or the mentally ill. What are those specific protections that are put in place? Because from my review, there's no requirement for an assessment by a psychiatrist for someone who might be experiencing something such as severe depression.
Minister.
Thank you, Mr. Speaker. The proposed legislation excludes people whose sole condition is an underlying mental illness, and that is because we still don't know enough about how the desire to receive the service of medical assistance in dying might interact with a particular mental illness. I will say that this in no way negates the suffering that people who are struggling with mental illness feel. I personally have worked with people who have severe mental illness and fully understand that that suffering can be very immense. But we also know that as part of the expression of a variety of different mental illnesses, the desire to end one's life is one of those components. And for that reason, we believe this is deserving of extra review through the parliamentary reviews scheduled in June. Thank you.
Questions and comments. Honourable member for Saanich Gulf Islands.
Mr. Speaker, and I thank the Honourable Minister. This is a topic that's come up quite often in the round of questions to the Honourable Minister. But I do note that the legislation before us includes, where appropriate, ensuring that the patient has been informed of other means of alleviating suffering, including mental health services, counselling services, palliative care. And I wish to ask the Minister again for some real specifics. We clearly are nowhere near having adequacy in any of these areas. So it's fine for the legislation to say the patients may be advised of access to these things, but access is inadequate.
Honourable Minister.
Well, thank you, Mr. Speaker. I thank the member for her question as well, because I agree, as the Minister of Health, that's part of my job, is to improve access to health care across Canada, and certainly wouldn't be my mandate letter to improve that if in fact we thought that everything was perfect. But we do know that the work is underway with the provinces and territories. I mentioned the $10 billion investment that happened a couple of years ago. Obviously in my mandate, things like access to primary care, improving supports for addictions and treatment in communities, these are the kinds of things that the Prime Minister has asked me to do. In the meantime, we know that Canadians also want to have autonomy at the time of their death. And so this is an important balance that we have to strike. We have to make sure that we're continuing to work in ensuring that Canadians have equal access to services all across the country. The legislation says that people need to be made aware of services in their community and available to them, so that in fact they are fully aware that the choice they're making is truly one that reflects their own particular circumstance.
Time for one just last short question. The honourable member for Humber River, Black Creek.
Minister, I certainly applaud the intent and where we're going with this changes to the legislation. But I think the concern has to be, at the end of the day, we pass a lot of money down to the provinces, and we expect them to do certain things with that. Ensuring palliative care and all of the other services, of course, are available is important. Is there a Fed-Prov group together that is going to ensure that a fair amount of the funding that we continue to transfer down gets to the very areas that we want, which is ensuring that people have access to palliative care and other resources?
Honourable Minister.
Thank you, Mr. Speaker, and I thank the member for her question. Absolutely, there is a federal, provincial, territorial working group that works very closely together to try and determine how we create an equal access to services across Canada, how we make sure that the investments we're making are resulting in differences in the access to care for people independent of where they live, and that we work together to uphold the Canada Health Act. And this is something, as you know, that the Prime Minister takes very seriously, as do I. And so, as I've recently tabled my findings under the Canada Health Act, we'll be pursuing with provinces and territories their obligation to make sure that they're providing services that are afforded to all of us through the history of healthcare in this country. Thank you.